and welcome to The Nation. I'm Jessy Chahal. On today's edition, we present to you this topic. We want to get the different perspectives on the Sulu Claimants case and what lessons we should all know from this entire issue. On today's discussion, I have a couple of guests joining me. Firstly, Ahmad Shamil Azad, advocate and solicitor. We'll also talk to constitutional lawyer Sin Yew, and shortly Azmi Hassan, geo-strategist from Nusantara Academy, joins us as well. Now, for perspective, the 6-month imprisonment and a ban from practicing as an arbitrator for a year that has been imposed on the Spanish arbitrator Dr. Gonzalo Stampa by the Madrid court recently marked another milestone for the country's success in the case against the purported heirs of the defunct Sulu Sultanate. The sentence was handed down to Stampa, who issued a purported final award of $14.9 billion, or equivalent to 62.59 billion ringgit, to 8 self-proclaimed heirs of the defunct Sulu Sultanate after the court on January 8th found him guilty of contempt of court. Fast forward to where we are today, of course, joined by our experts in the field. We get their perspective on this ongoing issue. First things first, let me bring in Sin Yew, constitutional lawyer, who tells a little bit more about this. Sin Yew, welcome to The Nation. Given the recent developments in the Madrid Criminal Court sentencing of Gonzalo Stampa, what significance does this hold for Malaysia in the context of the overall Sulu Claimants case?
Well, firstly, thanks for having me. And to answer that, well, Gonzalo Stampa was found to be in contempt of court for defying a Spanish court order to close arbitration proceedings immediately. So this is the 2001 order by the Madrid High Court of Justice, which had annulled its 2019 appointment of Stampa as the arbitrator in the Sulu's claim against Malaysia. I think it's important to point out that it was reported that the Madrid High Court said Stampa should have followed the Spanish court order instead of carrying out unethical and unprofessional conduct by moving the arbitration proceedings to France before finally ordering Malaysia to pay US dollar 14.9 billion to the Sulu claimants. The significance of this decision is that it reinforces the entire notion that these arbitration proceedings have been tainted with illegality, in particular the Paris's chapter of proceedings, and that all efforts to enforce the illegal arbitral award was really made with no basis whatsoever. And the Malaysian government really should explore the possibility of seeking damages against Gonzalo Stampa for his actions.
Right. As a legal expert, Sin Yew, how do you assess the Madrid High Court's decision here in terms of the annulment of Stampa's appointment?
I think it's certainly the correct decision. The legitimacy of the entire arbitration proceedings lies in the fact that his appointment is from the Madrid High Court in 2019, and once that has been revoked, everything that happened thereafter is illegal. I think the arbitrator acted in clear defiance, knowingly acted in clear defiance of the court order, and should be responsible for much of the bad publicity and damage to reputation, as well as the unnecessary costs which Malaysia had to suffer.
Right. Let me just jump in there to ask you, I mean, it's one bad apple, so to say, or perhaps, but what implications could this possibly have on international arbitration practices, if any?
I think I would caution against being an alarmist, because this whole Sulu claim and arbitration proceedings, it's a very rare case. It's based on an 1878 agreement with very different parties, some longer there. But you don't see these cases very often. So I wouldn't say that in this case in particular that any significant impact on international arbitration practice.
Right.
It's more of a arbitrator taking it into his own hands.
And so in your opinion, what steps can Malaysia take at this point to strengthen our position in terms of international arbitration cases, and also in instances where we need to protect ourselves in the future, given that this has already transpired? Where does this, or what steps can Malaysia take at this point?
Well, like I said, this is a rare and unusual case. And given the circumstances of this case, where this arbitrator, he had proven to have taken matter into his own hands, acting in defiance of a court order, there's actually very little that Malaysia could have done in the first place in light of this singular act of contempt that this arbitrator had undertaken. So, yeah.
I mean, we go back to February 28, 2022, and it is reported that the Sulu claimants have attempted to seize Malaysia's oil firm assets in Luxembourg, also assets in the Netherlands, and targeted other Malaysia diplomatic assets that were present or that are present in France. Simply put, Sin Yew, how would you generally simplify and explain this to viewers today in terms of the significance of this court conviction in the context of a nation's legal battle?
What I would say is that this entire episode was concocted by these claimants who alleged that they had rights towards the 1878 agreement. And I think there has been a certain conspiracy and design in the bringing of this claim, especially when you consider the fact that the arbitrator, now found guilty of contempt of court, had in many ways assisted this claim and making an order which he had no business making in the first place, or even hearing the proceedings when he had no power to do so in the first place, and when ordered to stop, refused to stop. So how I would put it in layman terms is that this is a rogue arbitrator acting in conspiracy with certain claimants, unknown claimants, damaging the government as well as Malaysia's interests, and smearing it not just domestically but internationally. It's how
very quickly, very swiftly as well, where does this leave us in the entire journey of this case? Is this the end of the road?
I think now it would be the end of the road, because the arbitration declared by the Paris Court of Appeal to be invalid. But I don't think that the Malaysian government should stop here simply because the arbitration proceedings is declared found to be invalid. I think they should consider pursuing against Mr. Gonzalo as well as the Sulu claimants for the damage that they had done.
Thank you, Sin Yew, for jumping on this call today and explain to us a little bit more around the legalities here. We'll speak to you soon. That was a new Sin Yew, constitutional lawyer, joining us to give us a more light and more insights as to the arbitration processes that has gone on. We take a quick breather. When we come back, more happening right here on The Nation. Ahmad Shamil Azad joins me. Stay tuned.
Lebih 50% keluasan tanah kita diliputi kehijauan. Hutan kita merupakan sebahagian daripada sumber semula jadi yang boleh diperbaharui dan mampan. Seperti kayu, negara kita komited sepenuhnya terhadap pengurusan hutan bagi memastikan ekosistem dan produktiviti hutan yang mampan untuk generasi hari ini dan masa depan.
Welcome back. You're watching The Nation as we try to get perspectives and understand the lessons from the Sulu Claimants case. Joining me right now via phone is Ahmad Shamil Azad, in fact via Zoom, advocate and solicitor. Welcome to The Nation. Shamil, thanks for being with us. As we reflect on Datuk Sri Azlina Othman's statement, how would you evaluate the role of the Malaysian government in addressing this Sulu fraud and pursuing justice in this case?
Thank you for having me. Looking at the efforts of the Malaysian government and its legal team, I believe they've done a tremendous job. They've challenged the claimant steps every step of the way. For example, when we brought a challenge against the appointment of the arbitrator himself in the Madrid court, and the appointment itself was nullified. And the Madrid court had also ordered for the process to stop and no longer proceed. And at every single step, when the arbitrator himself decided to provide for an initial award, that was challenged, and there was a stay of execution, and finally it was defeated. Even further, when the claimants attempted to execute the judgments, the award, I beg your pardon, at Luxembourg, Paris, and Netherlands, all three of the applications were successfully challenged. So I would say that the team has done a tremendous job, but it is not yet over. The final award is still being decided upon, whereby we've challenged the final award that was given by Dr. Stamper and are now awaiting judgment by the Paris courts.
Now, this is the case. A Spanish arbitrator has been convicted. How might this, if any, affect the diplomatic relations between Malaysia and Spain from this fallout?
Truth be told, I don't think there will be much of an adverse effect between the relations of the two countries because, as you can see, though the Spanish courts were the ones to appoint Dr. Stamper, when this matter was promptly challenged by the Malaysian government and its legal team, the matter was addressed quickly and accurately, and Dr. Stamper's appointment was annulled. And when we brought a complaint against the criminal actions of Dr. Stamper, the matter was also heard, and he was found in contempt of court. Now, this has really no likely point to do with the government of Spain itself, but the judicial system worked properly in this sense, and we've addressed the situation properly.
Now, from a legal standpoint, Shamil, do you see a need for any reforms or perhaps any adjustments in Malaysia's legal and arbitration framework to prevent similar issues from arising in the future?
Well, truth be told, we have a solid foundation already as it is, and it's been working quite well. Now, we have to also separate the situation in this current case as a special case, whereby there were clear abuse of process by Dr. Stamper, and even upon being told to cease further arbitration on the matter, he proceeded to defy the order. Now, I believe we as a nation have already addressed and also have included arbitration as part of our process in dealing with disputes. I believe there's, of course, room to improve, but as it is, I believe we are in a good place. We have good, solid foundation, especially with the establishment of the Asian International Arbitration Center here in Malaysia.
Now, what impact would this have, or such a case have, on the public trust in terms of the legal system, not just domestically, but I think more so here internationally?
Okay, yeah, true. We were deeply shocked as a nation when the award was given, and we were shaken that something like this could have happened without us knowing it. However, when you look at it, the judicial system has provided a way to right itself, whereby when we, with our legal team, challenged the matters in court, the matters was promptly addressed and justly decided upon. So when Dr. Stamper's appointment as arbitrator was cancelled, and we can also see that he was further ordered to cease from further arbitrating the matter, it can be seen as the judicial system or the legal system righting itself. Furthermore, all the different applications that were made were duly heard and was promptly rejected. This goes to show that the legal system itself is working. In order to perhaps bolster confidence in our legal system and the international legal system, I believe prompt reporting and even updates from the country of matters like this can be posted more often. The people to feel as if they are in the loop.
Now, given the international nature of this case, of course, it has made headlines across the globe. Do you think there is room for an increased joint venture or work between nations in establishing and then further enforcing ethical standards for arbitrators?
Most definitely. I believe any collaboration between countries would provide for a better understanding, and of course, we can streamline the process of arbitration to avoid such issues as this in the future. I believe if the countries come together and address matters pertaining to the election of arbitrators and also addressing issues pertaining to rogue arbitrators, I believe we could provide for a better system. And of course, we all, welcome all these collaboration between countries to address issues like this in the future.
And moving forward, before I let you off, Shamil, how do you think YB Azlina handled this entire issue? She was very much present at the forefront, coming from a legal background herself. How did you think this was handled?
I believe this was handled exceptionally well because she kept the public in the loop, of course, with Twitter postings, reportings to the media, telling the people what truly happened. And in some ways also explaining what people might not feel in depth, would not have in-depth knowledge about. And I believe they've also set up a website for explaining the situation between the Sulu claim. And that has really, really helped Malaysia come together and understand the situation. I believe she's handled the matter really, really well. And it has bolstered our confidence in the government in handling matters like this in the future.
Ahmad Shamil Azad, advocate and solicitor there. Thanks for joining us. We'll speak to you soon. We move on now. Before we're joined by Azmi Hassan, we take a quick breather right here on The Nation. Do stay tuned.
Hai adik-adik, jom belajar cara melintas jalan. Lihat kiri, kanan, kiri sebelum melintas. Membantu pelajar melintas dan pastikan pelajar selamat sampai. Jangan tiru pemanduan seperti ini. Contohi pemanduan dan peraturan dengan berhemah.
Senyum segar di pagi hari, terus bangkit yakin berdiri. Segala sentosa.
Welcome back. This is The Nation. I'm Jessy Chahal. We are looking at getting perspectives and understanding the lessons from the Sulu Claimants case. We were joined previously by two guests. On the line right now is Azmi Hassan, geo-strategist, to explain to us a little bit more about his perspective. Azmi, welcome to The Nation. What's the geopolitical significance of Malaysia's involvement in this Sulu fraud case, considering Dato' Seri Azlina Othman's statement?
Yeah, Jessy. No, I've read today's news regarding the statement from Paul Cohen, which is the lead lawyer for the Sulu clan or Sulu claim. He said that one of the reasons why the Spanish government persecute and penalize Gonzalo Ampa is that because of Malaysia is procuring some military equipment, and this Spanish government is doing a favor in terms of Malaysia to acquire military equipment from Airbus instead from Boeing or from another various states' defense companies. So these are the geopolitical implications, as I read this morning. It is a very, I think, laughable, or I would say a nonsense argument made by Mr. Cohen. The Spanish government prosecutes Sampa just because to carry some flavor from Malaysia regarding military equipment. But again, it has some geopolitical implication in this case, Jessy.
Well, then, how might the Sulu case, how does it affect Azmi within the Southeast Asian dynamics in terms of, you know, this being a Spanish arbitrator that's been convicted as well? Does it have any play in power dynamics here in Southeast Asia?
Yeah, Jessy, in terms of regional implication, we know that the Sulu is from the Philippines. Even though Manila said they have got nothing to do with the Sulu claim, but again, against the backdrop of Manila claim to Sabah, towards Sabah, saying that Sabah is theirs, and also the Sulu claim is something to do with Sabah in this case. So I guess it has some regional implication. But I'm sure Manila and Kuala Lumpur can handle this particular issue. One thing for sure, Jessy, is that this particular claim of Sabah belongs to the Philippines, or the Sulu said Sabah, for the Sabah, they should get more compensation. I think it's been used, a lot has been used in the political arena of the Philippines itself. So I guess it won't spill out, I think, for the other region. But as I see it, this has been going on for a long time, and I'm sure Kuala Lumpur, Putrajaya, and Manila can handle these bilateral sensitivities, Jessy.
Azmi, you know, this of course has had an impact on Malaysia's image to a certain extent. How do you think Malaysia's handling of this case has had an impact on its global image, and what role will perception play in this context moving forward?
Well, Jessy, I think the line is very poor, but from what I can gather here and there from your question, I'm not sure. Can you say again?
I was just going to ask you about Malaysia's global image at this point, given the impact of the Sulu case, and how does this come into play with public perception of Malaysia?
Yes, I think nothing wrong with our image, because we have been doing this, make an appeal to the Spanish court, made an appeal to the French court, and also the Netherlands court. We have been using this particular international law instrument according to its specification. So to accuse us maybe as a bully to the Sulu clan, I think it is not fair. And I think we have been bullied, not specifically by the Sulu, but the people behind the Sulu claim, the people who finance the Sulu claim, most probably Mr. Paul Cohen and his associate. I'm not sure. But again, in terms of Malaysia spending in the international arena, it demonstrates that if you follow the law, I think if you are in the right, I think as in Malaysia in the right, I think the law will favor you. So there's nothing wrong with Malaysia image at the international arena, Jessy.
And in this case, of course, the law has prevailed to bring justice. Azmi Hassan, thank you very much for joining us. That was Azmi Hassan, geo-strategist from Nusantara Academy. We were earlier joined by Ahmad Shamil Azad, advocate and solicitor, as well as a new Sin Yew constitutional lawyer, all giving their perspectives and sharing the lessons from the Sulu Claimants case. Thank you so much for joining us on this edition of The Nation. Keep it locked on to Bernama TV. Many more updates coming your way. Bye.